Thank you, everybody. For this part, we are very honored and privileged to have Professor Prof from the Geneva Academy with us. So we'll let Robert explain about capacity and role, which he can do much better than I can, and then present the presentation. Floor is yours.
Thank you for the invitation. I have simply a series of papers for the consider. The first is my outline, so it's a simple outline for you, in order for you to know where I'm going. And the others are sources probably known from most of you about the convention on financing of terrorism, Security Council resolution, and the two main provisions in H and international humanitarian law, so-called acts of terror, which is that's equivalent to terrorism. That's part of the discussion. Okay. So thank you very much. And while it's circulating, just was an introduction on where I come from, not my family, but my professional activities. So I'm a professor in Geneva at the Roth faculty, and since I came back from The Hague, I will mention it briefly in 5 minutes. I've been appointed as director of the Geneva Academy of International Humanitarian Law and Human Rights, which is a center, a joint center of the University of Geneva and the Belligerency Institute of International Development Studies in Geneva. The Academy runs 3 programs, LLM in International Humanitarian Law, an executive master in International Humanitarian Law, and now Master of Advanced Studies in transitional justice, with a series of very talented assistants, including an Israeli young lady who is known to some of you, at least we do, I know, Bengal, who happens also to be the only Swiss in the group. She's also Swiss. So it's a very innovative, it's one of the nice things. We have a series of assistants from Italy, Georgia, France, Ethiopia, Russia. It's a very multinational group. And beside that, we have a research department, and one of the fields of research is counterterrorism, especially the question which I would like to address of foreign fighters, which likely in Europe is. We anticipated a bit, fortunately or unfortunately, we anticipated a bit that it would come as a first thing in the media, but also in the legal discussion. So we have worked on foreign fighters and the issues about human rights, etc., for a couple of years. And if you are interested, you'll find on the website of the Academy the briefings, and one of the last briefings is a quite substantial briefing on maybe 80 pages, but very comprehensive on the question of foreign fighters and the international law, and without promoting the products. It's good. It's very good. And it's considered, no, but it's considered probably as the best paper on foreign fighters under international law in Europe, at least because she is the author, because she's invited that in Strasbourg, in Brussels, to present. So my own background, I mentioned that we were in The Hague. Well, the summer is like here, but it lasts only one day. Nice day. No, but I worked for 2 years as the presiding judge of the trial chamber of the Special Tribunals for Lebanon in The Hague. I left in 2013. I will not speak about my experience. That would be a topic for another lecture or speech if you would like to. I did it in the University in June with Noam Jihad or Jihad Noam, who invited last week. So, but I will not expand on this. Simply that we arrived at the public affairs section. We arrived in The Hague a few months after the decision, which I didn't put in the paper, but you probably know, decision by the Appeal Chamber of the Special Tribunal for Lebanon, which is meant to be completely essential in the discussion I want to have with you this afternoon. The decision of the appellate chamber of the STL of 16th of February 2011 is mentioned in the outline. You probably know that for the time being, it's the only international decision trying and succeeding in its own view, even if it has been criticized a lot, right? But the first international decisions giving a definition and the limits of a definition of international terrorism. That's why this decision for the moment is very important. That the moment where another court will probably issue a decision. For the moment, it's the only one. It has been drafted by our mentor, many of us, yes, including this room, Antonio Casillas, who was at the time the presiding judge, the president of the whole family, and passed away a couple of months later. That's on my background. Perhaps to begin with, just on the sources, again, probably most of you are completely aware of the whole thing, but for the ones who perhaps are less familiar with the legal set, especially for political sciences, probably who are less familiar with the legal setting of the question of international terrorism, my topic will be, as in the title, the impact on criminal law of the discussion. But before discussing the impact, actually, I have to well the discussion stays with the definition of international terrorism, and the difficulty begins with the question where it's the crime of international terrorism or international crime of terrorism, which is not the same thing. On the sources, simply to put the context, you already know that for the time being, there is no comprehensive convention, general convention on terrorism, but a series of quite important and conventions on specific aspects, and I underlined the two main conventions and asked to have a photography of the most important one, the time. And the two main conventions are the Convention on Bombing, so on attacks through bombing, and so the Bombing Convention, and the other is Convention on the Financing of Terrorism. The interesting thing is that this convention actually had widely ratified, and this convention, as the dates indicate, why all these dates date before 2001. So it's before the turning point of the attacks on 9/11 that this convention were drafted. On the comprehensive convention, you probably also know that for the moment, everything at the moment lasts since 2004. Everything is stalled, except for some minor work, because of a series of points. But the main point is the question whether the so-called freedom fighters, or the freedom fighters shall be immune from being labeled as terrorists. What would be the statute of so-called the freedom fighters in an international convention on terrorism? On this, there are actually very different views from the Western countries on one side, the countries on the other side, and everything has been sold since 2002. So we have a draft which is close to being adopted, but it's not adopted and shall not be adopted probably not. I cannot refrain from quoting the Hindi of 1st of July of this year. I'm not a subscriber to Hindi, as you can imagine, but with internet you find everything. So Hindi is more or less is close to the present Indian government, and I just quote because it's funny for you, I guess. Perhaps some of you have read it. Adding to the because India is pushing a lot for this convention, is the main, for the moment, is the main actor in the work for the completion and the achievement of the work on the comprehensive convention on terrorism, which would substitute or complement the conventions on bombing, finance, nuclear weapons, etc. I quote, adding to the government's confidence on the adoption of the comprehensive convention is the fact that the committee that will hear India's case, so Indians pushing, in meetings due to start in early September, so this day, will be chaired by Israeli ambassador to the UN, Danny Danon, was elected to the sixth committee that deals with legal issues as well as measures to eliminate international terrorism. So the Indians are very confident because Mr. Dana is heading the committee as of June. Bon. Beside the conventions, you know also that the security council have been very active on this, and for us lawyers, actually, it opens a lot of questions, especially the role of the Security Council on kind of legislator in this field, because Security Council normally issues actually political decisions, but in some instances it goes far beyond the decision. It's very close what they are doing, and I give the example of the resolution 1 of 18 goes far beyond, and is very close in its drafting to conventions, where states ratifying conventions commit themselves to go in a specific direction. The difference being that the Security Council resolutions are adopted by a tiny minority of states and is binding on the other states. So it's a kind of hybrid situation, and we'll not too much elaborate on it. It's a wonderful specific subject of research where a political body issues commitments for states where the states do not, in principle, have the choice to abide or not abide with by ratifying or not ratifying because they are bound. Security Council resolution, especially the case for this resolution in point 6, where really you have a series of points which should be in the convention ratified and discussed by the community of states and not only by the people of the states in the Security Council, with naturally the overweight of the big five. Last point on the sources, this decision of the Appeal Chamber. I don't know if some of you have read it or studied it, because we're reading it based on time. It's 170 pages, issued 3 months after the question was asked to the court, which means that was already before. That's how judicial bodies function from time to time, with 3,000 footnotes. But the bottom line is that according to the Appeal Chamber, there exists in present international law in 2011, 2016, a customary law definition of terrorism in times of peace. And there is no such definition in customary law, under customary law, for terrorism in times of war. Both are completely disputed, but that's the point of the Appeal Chamber. And then the Appeal Chamber elaborates on the elements of the crime of international terrorism in times of peace, since we cannot address that was also problematic. They cannot address terrorism in times of war, since it doesn't exist beyond the conventions. But terrorism in times of peace, and the definition they give to terrorism in times of peace, is very close to the kind of best of or patchwork from the different conventions, including the convention I mentioned before, from parts which comes from AHL, which raises the problem whether what has been decided for terrorism crimes of war can be applied in terrorism in times of peace, on which AHL specialists dispute, as you probably know. And they identify a series of obligations under customary law, not for states not to engage in terrorist actions, not surprising, an obligation to prevent and suppress terrorism, which is beyond, and a right, and that's a real Cassese approach of international law, found the after decision of the SDY, a right to prosecute terrorist acts and cooperate to prosecution of other states. So two obligations, which are quite simple. The first, indisputable, the second, okay? And then the right to cooperate, which derives from international customary law. That's the way Cassese makes international progress in this question. That's for the interaction. Then on the qualification and the consequences of qualification, which is my second point, that's my outline. As I say, the first question, in order to be very precise in words, lawyers, and good lawyers like to be precise in words, So sometimes the place of adjectives and names is important. You have two different questions, and sometimes they are mixed or they are merged. They are two different questions. The question of a crime of international terrorism and the question of international crime of terrorism. We don't have the same approach, the same answer approach. The first, the crime of international terrorism, addresses the substance of a crime and raises the question, what are the characteristics which shall be met in order for a crime to be labeled of international terrorism and not terrorism? One thing that, in my view, rightly, that can be discussed, the Appellate Chamber underlines, is the fact that a crime may be international terrorism, even if it's confined within the limits of a defined state. Naturally, the question had to be discussed like this, yeah, because you probably know, because we are in Israel, in January, in other countries, I have to expand a bit of this, but I think here I don't have to expand the fact that the institutions of Lebanon was established in order to try and to organize the trial for the assassination of the former Prime Minister Hariri on February 2005 in Beirut. So it was a crime allegedly under the prosecution case committed by Lebanese against the Lebanese victim as a target, and as very often in terrorism you have the target and you have the victims, which are different. So the target was Hariri and the victims were 23 people, innocent people, like maybe I like to say from time to time, people who were on Boulevard Saint-Georges in Beirut at the time of it. All these people, the victims, and the alleged perpetrators are Lebanese. So it's a Lebanese case. Nevertheless, according to the STL, it's a case of international terrorism because of the effects of this crime on the region of MENA, on peace and security, etc. So, for the STL, the definition of international terrorism cannot be boiled down to the fact that it's a crime which has been perpetrated on more than one territorial state. So you have to consider the effects. Naturally, it's more flexible that if you would have a territorial approach. I draw your attention that it's contrary to what is stated in the Convention, for instance, of Financing of Terrorism, Article 3, and in the present drafting of the Comprehensive Convention, which is overwhelmed overcome by the decision of the STL, where international terrorism is defined by the fact that more than one state is concerned. That's probably something which now will not come back in the discussion, so you have to find other criteria. I also drew your attention that it's not only the STL, but probably the seminal decision was a resolution of the Security Council in 2007, so some 10 years ago, after the assassination of Benazir Bhutto. And the resolution, the Security Council issued a resolution condemning the assassination of Benazir Bhutto and labeling it international terrorism. Whereas the victims were all Pakistanis and the alleged perpetrators were all Pakistanis. Nobody alleged, and still is alleging, that it would be something international, but India, for instance, would be both. It's the Pakistanis story that the Security Council labeled as international. So international terrorism may be something which happens only in one country, in one state, and then you have to find the approach criteria which have the effect on the region, the security, etc. That's for international terrorism. It's analytical. The second instance of the second question, an international crime of terrorism, addresses the question whereas the crime itself has reached the importance of being considered a part of international law. Be it regional, be it national, etc., it may be part of international criminal law. And part of, since we don't have for the moment convention which would label terrorism as an international crime in some circumstances, series of circumstances, which would then belong to the war crimes and not to the duty crimes, since crimes for the moment don't consider terrorism an international crime. What are the criteria? So it's the question leads us back to Roth. It's a classical question: what is an international crime? Is it a crime which addresses the main values of humanity, etc.? That's terrorism. Infringe on essential values of humanity, etc. Sometimes the reasoning is quite circular, because some scholars would say the offense is an international crime, terrorism in this case, if it entails individual criminal responsibility, which goes beyond the responsibility of criminals before national laws. But here it's at the same time the cause and the consequence. Because if it's an international crime, naturally it goes beyond national laws. For me, it's not a criteria, it's not to define what is international crime, it's the consequence. So you have a kind of game of chicken and egg. What triggers the fact that some crime, terrorism in this case, would be an international crime? It's a still open question, as I say, open since the time of Roth, which we can speak of current, but it's open since posthumous on all crimes, like conspiracy and piracy and influence of terrorism. Then, so that's for the qualification. Just a word, perhaps, for those of you who are not completely familiar with this approach and with the problem of terrorism in times of war, where we leave customary law according to the Sierra Chamber, according to most of the scholars. Some scholars will say that there is something we have to customary law definition of terrorism in times of war. The Hague Chamber and most scholars will accept that there is no such thing. So you have to refer to the Geneva Convention and their protocols, and there is not much. So you have to refer to the case law. And the similar case, I forgot to put it in the outline of the know this case, I studied this case, there are not so many cases on this. It's a Gallish case by the STY in 2009, the Gallish case where the STY, the Statute for ex-Yugoslavia. The most interesting thing is that it made this nuance of labeling acts which in the common language would be called terrorism, not as terrorism, but acts of terror. And that's an important nuance based on the two bases I've reproduced. So Article 51 of the first additional protocol and Article 13 of the second additional protocol. Let's consider it customary law for the moment. And the only provisions in the Geneva Conventions and Protocol in Geneva law which really addresses the definition of something which the Gallic Appeal Chamber, which was followed by, for instance, Sierra Leone special court, but exactly with the same approach and logic in the discussion, the Gallic Appeal Chamber said it's acts of terror. And the definition, that there is a legal definition, is included in Article 51 of the first additional protocol. Why is it important and why did the Gallic, as I understand it, not use the word terrorist but act of terror? It's important for two complementary reasons. The first reason is that it's not necessary to label this act which spread fear among the population, the civilian population. They don't have to be labeled as international crime or as terrorism, since they are war crimes. Since they already belong to the category of war crimes, you don't have to add something which would not add anything, because as war crimes, naturally they are international crimes. You don't need to do this. And on the other hand, the Gallic Appeal Chamber considered it was important not to use terrorists in this context because groups labeled as terrorists may act in times of war without committing acts of terrorism. Because if they target only military objectives, don't meet the definition of protocols, they are not performing acts of terror. And it's important for reconciliation, for serious point, just to distinguish between acts of terror and terrorism. And so the label of terrorist group does not lead to consider the acts performed by these groups during the conflict as acts of terror. They are acts of terror, but they are not terrorism. I think that's a very important nuance. And once again, the reason why this nuance is so important is that these groups may participate in a reconciliation process without being charged with war crimes, because even if they are terrorist groups according to Security Council resolution, etc., if they have not performed acts of terror, they have not performed war crimes, so they're immune to prosecutions under international humanitarian law, and then they can participate in reconciliation processes if these reconciliation processes exclude groups which have performed war crimes. So it's quite important to distinguish the two, and that leads today to a situation where you don't have such thing as terrorists in times of war. You have acts of terror, and then you have terrorism in times of peace for the echo chamber, or the ones who follow the echo chamber, and then you have the groups which are labeled terrorists by Security Council resolution, even conventions, etc., national law.
Just a point of clarification. I totally understand the importance of distinguishing the group and the acts of groups, including terrorism. Is it only for the purpose of, is your statement that it's just for the purpose of post-conflict reconciliation, or is there some other?
But there are probably other reasons. I really probably to take shortcuts, but I think it's the main, at least, advantage of the situation. That it's a question we discussed in a sense in the last session. The label of any legal word has implications, and the application was completely aware of the fact that the label terrorist has a series of implications. We discussed the implications. And if you label things as terrorist, naturally you have a series of consequences. Whereas if you label it an act of terror, the consequences are what they should be, consequences under the laws of war and the prosecutions for war crimes. And that's it. The other consequences do not follow from the perpetration of acts of terror. For instance, the regime of detention may be exactly the same regime as for the other perpetrators of other participants who have the conflict. Whereas if they are labeled terrorists, naturally it has consequences of regime of detention, disputable consequences naturally. But you see, so there are some results. And I will come now to the question of the consequences. Back to consequences of the label of terrorism, and leaving aside the question of acts of terror in times of war as war. So back to terrorism as labeled by convention, as labeled by domestic legislation, which has followed the convention, implemented the convention, or which has invented its own definition, because naturally, as you also all know, the fact that there is no comprehensive definition of terrorism types of peace has led countries to have different definitions with a series of consequences, which were very well illustrated. If some of you know the case, and there was a very good piece of the film on this by Gal and Antonio Bucco to the assistants of the Academy. The decision of the English and Wales High Court on a case in Poole, who was accused and convicted as a terrorist under English law as a Kurd taking part in so-called terrorist action in Turkey. And then here, the English court decided for a definition of terrorism. We do not rely on international law since there is no definition in international law for the act of terrorism, the definition for financing, but not for terrorism, and expanded the definition of terrorism with consequences which are identified in the piece of Foucault and Gall, which may be quite important. For instance, some, if this definition is accepted, some groups or persons who assist other groups or other persons taking part in the Syrian conflict may be labeled as participating to acts of terrorism, according to the definition given by English law, which have also consequences, at least in England, for their participation, for their assistance, even medical assistance to groups which are taking part in the conflict. To come back to the consequences, it's interesting for, especially for European, somebody who has worked a bit on the evolution of European law, to see that often some legal features are considered as consequences of the development of terrorist law, where they come from elsewhere. And I will give you, because you find this on the list in some scholarly pieces. For instance, the criminalization of preparatory acts. Very often you read that came with terrorist legislation, anti-terror legislation, which is not true if you consider history. The incrimination of preparatory acts came with the fight against organized crime in the 70s in Europe, and not with the terrorist legislation. So naturally it was included in anti-terror legislation, but it's not an outcome of anti-terror legislation. The same for undercover operations, which also come from the anti-organized crime legislation and not for anti-terror legislation. So when you read these kind of accounts of all the effects, and with good coming from very good colleagues, you may be a little cautious and come back to the history really of the institution. For me, there are three main consequences of the label of acts as acts of terrorism. The first is on the restriction of defense activities, which really is specific to terrorism, because we didn't have the same with organized crime, because legislators or judges did not consider that generally the lawyers for the organized crime would be part of the organized crime themselves. Whereas in terrorism, in anti-terror legislation, the problem was very often that lawyers were supposedly too close with the organization or the person they would assist. So the restriction to defense activities. The second point is naturally the regime of detention, which I mentioned before. The regime of detention, once again, for organized crime, there was some measures, but not what we experienced with terrorists or legal terrorists. And the third is probably the most important, is the neutralization of obstacles to mutual legal cooperation. That really comes, especially Europe, and here I consider European situation from anti-terrorist legislation, and as early in 78, the first convention, European Convention on the auspices of the Council of Europe, was adopted against terrorism, and the main point in this anti-terrorist legislation, 78, so it's naturally a reaction to Brigate Rosse in Italy and all the army council in Germany. This convention mainly dealt with the question of cooperation, because even cooperation between European countries was very complicated, and it adopted, for the purposes of cooperation, definition of terrorism, which is still valid because it hasn't changed through the convention. The states decided to adopt a definition for the purposes of cooperation, and this definition would allow cooperation and would not allow the people who are supposed to have perpetrated this act to invoke, for instance, a political offense exception to cooperation. So when a crime responds to the definition of terrorism under the convention, your current state cannot accept, cannot discuss the political offense objection, and that naturally has made the cooperation far easier between you. So these are the three main different but main consequences: restriction of defense activities, regime of detention, and reduction of obstacles to cooperation in criminal cases. Then the structural question about this institutional establishment of a body of law about terrorism is the question of fragmentation of criminal international fragmentation of criminal international. And the problem is also well known in Europe because you have exactly the same problem with the provisions in European criminal law which have harmonized parts of criminal law for the purposes of the prosecution of crimes against the interest of the offender. You have a series of provisions with which the European states have to align to the these kind of things for the purposes of fighting against fraud against the EU budget. So it's the level of gravity is completely. But the problem we have experienced today is that to have two different bodies of law, one for the cases including an offense against the interest of the European Union, and a different body of law of general principles for the offenses, the general offenses, frauds, etc., against the interest of the domestic state or against the interest of private doesn't work because in the same case you have both offenses. So it leads to a kind of harmonization through a limited harmonization concerning only the offenses against quote-unquote European interest, but which spread over and which leads to harmonization of huge parts of criminal law. And for terrorism, it's the same. If you have a special regime for the terrorist offense, in practice, it simply does not work since beside the terrorist offenses, the cases include offenses against private interests which are not legal terrorists, etc. And you cannot, in a court, in a case, simply have two different bodies of law for offenses which are perpetrated by the same group or the same persons. Or you cut the case into parts. One part would be the terrorist case, and one part would be the non-terrorist case, but that's not satisfactory for several reasons, and it's not efficient, and it may lead to injustice. So harmonization of the law against terrorism, which has been, as I said, which has begun in Europe in 1978, which has continued framework decision of 2002, etc., leads to a kind of harmonization of all the political factors, which naturally is a thing. It's not a prejudice, but it's an effect which is more or less inevitable when you begin to harmonize the conditions for the prosecutions of terrorist cases. Then, perhaps on the impact, I will just take that from the convention and especially financing conventions and most of you know probably the kind of threefold obligations, the obligations to recriminate acts of financing of terrorism, so it's not about terrorism, but financing of terrorism, obligation to establish jurisdiction, and obligation to cooperate or to lift the obstacles to cooperation. And you have it in the financing convention quite clearly. If I remember well, it's Article 4, 7, and 8. You have this obligation, which you find in all conventions about the different aspects around terrorism, because it's never around terrorism itself. It's either on specific acts of terrorism like bombing, or about phenomena which are related to terrorism like economic intervention. You have these three obligations. The first, actually, on incrimination is part of this discussion about the harmonization of law, because if you have to incriminate, it makes sense to incriminate the same way, which is also related to the obstacle to cooperation. On the duty to establish jurisdiction, it's interesting to see that the connexity, and again, if you take an historical perspective, it's interesting that the connexity between the two criteria for jurisdiction, which you find in the conventions, and what you find in the ICC statute for the Roth statute for the ICC, the two criteria for jurisdiction which are compulsory are the same. So territorial jurisdiction naturally, and the jurisdiction based on the active nationality principle, so the jurisdiction based on the nationality of the perpetrator of the act. You know, that's the two triggering criteria for the competence of the ICC, and you find the same in the financing convention and both conventions. If you come back to the 70s, it's interesting because at the beginning of the discussion, contemporary discussion about criteria for jurisdiction, the main criteria was specific nationality, for the nationality of the victim and not nationality of the perpetrator. And that the paradigm had completely changed over the years. But it's very interesting to come back to this project, because there was not much achievement in this. But to come back to this project, the idea being that the first duty of a state is to protect its own citizens. And then this duty leads to the right to have jurisdictions that establish jurisdiction based on the nationality of the victims. And here the paradigm that completely changes, as you know, the fact that the person is a national of the state does not trigger the competence of the ICC. The state has ratified the ICC, and you have the same convention on terrorism. On the cooperation, I mentioned already the origin, at least in Europe, of this movement to lift the obstacles to cooperation, essentially the political offense objection or exception to extradition, which means that the person who is accused of having perpetrated a crime which meets the definition given in the 78th Convention may not bring the argument that his prosecution is based on political reasons or at least for her activities. This objection naturally can be raised before the judge who will try him or her if he or she is exploited, but not before the authorities or judges of the state which is asked to give cooperation for this business. And here the paradigm, unlike the passive possibility, the paradigm has not changed. It's always the same paradigm. You shall not have arguments against extradition in case of terrorism, and the main argument, essentially in the case of terrorism, is the same for other offenses, namely the political offense objection, which has lost its weight in this context. Well, here were the points I wanted to bring to the discussion, give my assessment of the situation as it is now, with no comprehensive convention on terrorism, and probably for some years to come, unless Mr. Belligerency find a way. So, but that's what the Indians think. The Indians are wise. So if Mr. Dunn doesn't find a way to open again the discussion, there will be no comprehensive convention. Although this cluster, which makes the discussion, entering the real legal discussion, quite difficult, cluster of convention actually with the same provisions essentially, with some differences, because the financing convention, for instance, gives indirectly a definition of terrorism beyond the definition which you find in the other conventions, difficult to find its way, and which did open the possibility to legislators or even to judges in cases they recognize law out of the books, and is it the possibility for the judges to introduce definitions of terrorism, to expand or restrict the generally to expand the definition of terrorism. One of the advantages of the convention probably to set limits to the definition of terrorism and not be able to not allow states, at least the states which have ratified this convention, to enlarge the definition of terrorism, and the success of the other conventions under the point of ratification has been quite important for the two convention, which is 2020 success. So these conventions are more or less universal. We expect that the comprehensive convention will be universal too, and fix limits, set limits to the definition, and probably also limits to the consequences, which would be consequences which would happen when the case is considered a case of terrorism under the definition of terrorism, convention definition, which would be implemented by the states when ratifying the convention. Voilà.
And response on
I have a question actually. Can you say a little bit more about the narrowest definition of terrorism versus the broadest definition of terrorism? What are the main factors? You mentioned that in the financial convention there is a very broad definition. Is this the broadest?
To my knowledge, it's the broadest one because of the purpose of the convention, and introduces, among other things, inchoate offenses, which was beyond what normally you would most legislation accept as simple offenses. So it introduces the notion of inchoate offenses. You have also in the definition more simple aspect. What's the subjective element? Do you define terrorism only when the intent is to spread terror, which is indisputable, or also when the intent or the purpose of the perpetrator is to oblige an authority to commit something or not to do something?
Change course.
Exactly. And that you have differences. And another aspect which is discussed in the STL decision, and on which the STL found there is still not consent, is the question of the political intent. Do you include in the definition the political intent of the perpetrator, or do you accept and then you restrict terrorism of acts which are labeled terrorism, of acts which are perpetrated with a so-called political intent? So it's not only spread terror, but it's spread terror with a political intent, or do you leave it aside and then you open naturally to acts of violence sometimes, which eventually are maybe defined over.
I want with your permission to pursue two aspects of this very interesting, and I think we should have started with this lecture the first day, and then we'd have a better sense of terrorism.
But they tried, to the benefit. They tried because I think the first invitation was for the first session, and I was not just.
So two questions. One, following, I mean, so there will be talks, I guess, about the possible definition of acts of terror. I can take this. This is actually a student. So there will be debates about that, and in all likelihood, you're saying that it's not in the near future that it will be solved. However, two questions. First of all, on the notion of jurisdiction. The second question will be the act versus the organization. On the notion of jurisdiction, the fact that there is no binding international prevention is, as this fascinating lecture reveals, does not curtail the daily operation of judicial bodies at the supranational and national levels to deal with terror, which means that there is some state practice that emerges within certain confines of, okay, do you have to show intent or do you not have to show intent? What about the effect? Does it have to have show? Possibility for effect, probability for effect, yes, no. But there's state practice. To the extent that the field is getting narrower by that state practice. State practice concept. State practice is so varied that maybe it's counterproductive. But to the extent that transnational law works here, or comparative law works here, states say, oh, this court did that and that court did it, so there's some narrowing effect. Sometimes it's called harmonization, regardless. If state courts take the brunt, or super like the European courts take some of the work, the question of jurisdiction really matters. Clearly passive, personal passive jurisdiction, or even passive, more like state interest jurisdiction. What about the emergence of universal jurisdiction at the state level? The ICC, that's what we have in Sharon in Belgium, and we have Pinochet in Britain, and we have other instances of universal jurisdiction where it's stable. So should we consider terror as one of the four, as part of the four crimes that actually serve as the ground of universal jurisdiction? Basically, this is question one. Question number two, and I realize this is not happening now, but we're talking about trajectories. What the beauty of your lecture is that it gives a trajectory, it gives a pattern. This is where we are now, and this is the process that. The second question has to do with this notion of organization versus act. The beauty of this definition, of this separation, means that sometimes state can be involved in acts of terror. Sure. And so that's the flip side. And it means that terror organizations not necessarily are always involved in acts of terror. Sometimes they're involved. Hezbollah, whatever, that recently, as of 2012, because it was involved in the war in Syria, of all things, got the label of terror organization. But with respect to its act vis-a-vis Israel, Hezbollah is more of a guerrilla organization, or whatever you want to phrase it. It acts less, uses less and less acts of terror because it targets soldiers or whatever. Which means that to the extent that we ever have rapprochement with Hezbollah, Israel ever has a rapprochement with Hezbollah, this is a point you're making about reconciliation. It's one thing, but the other thing is, does it mean that we should let go maybe of this definition altogether? Because who cares if a certain organization is terrorist organization? Let's judge act per act. So Hamas in Gaza performs multitude of functions. It helps Israel, it governs Gaza. It also engages occasionally in an act of terror. So let's focus maybe on the acts. Do we need the definition of the organization? Maybe it's counterproductive across the board.
I would like to follow up on that.
Yeah, sure.
The question between acts of terrorism and organization is basically the notion of guilt by association or affiliation to the organization, meaning that we want to criminalize the entire framework, the envelope of terrorism, not only the acts of terrorism. This is the main difference between acts enabling terrorism and acts of terrorism. And this is where as far as I see, the organization is coming into play. The need of the states to criminalize the broader definition. And this is the seek for.
But you will also then criminalize the cook. It's always a question of the cook. Because if you belong to a terror organization, and it's not just the person who committed the act, it's also the cook who made the food for.
But you're looking, you have conventions against the financing of terrorism.
That's right.
You have the
That's the
banker.
cook. That's the cook approach.
Yeah, there are a lot of things in the discussion. If I may give a service. The first, I would come back to came to my mind to one of your questions. Interesting part of the discussion in the STL decision, but you may read it with all the all the legal basis because it's somewhat quite complicated. It's interesting on a national level. For the ones who know the STL, the idea was to apply Lebanese law as long as it does not contradict with international law. So apply Lebanese law and in the case of the definition of terrorism, Lebanese law, if I remember well, implementing the Arab Convention of the Arab League against terrorism, had a list of acts which brings a restriction to the definition of terrorism. And the STL, in my view, is not completely convincing on it because it decides that that's not part of customary law. So since it's not part of customary law, we apply the so-called customary law definition, which does not include actually any list of acts, that never would customary law include a list of acts. It's completely an oxymoron because customary law is about principle, it's not about list of acts. So forget about the list of acts, which would have been an important restriction to the definition of terrorism. So remove it because it's contrary to international law. The problem is that the same statute of the STL also states that when a solution is more favorable to human rights, to the rights of the accused, it should be preferred. And for sure, the solution of Lebanese law was preferable under the aspect of the right of the accused, not of the right of the accused. So they have to make a kind of gymnastic explaining that it's more favorable to human rights, but it's contrary to customary law, where customary law finally cannot simply have a list of acts. But that's a way to come back to the answer where you can have a definition which is more. It has that effect because if you have a list, the list must be updated. All know that the legislation is better without list, but legislation without list is also more rules. So you have to apply. To your question of universal jurisdiction, again, you can go back to Consensus more or less, because the question is whether the labeling of international crime of terrorism, not crime of international terrorism, but international crime of terrorism involves recognition of universal jurisdiction, on which, as you know, around this table probably there are 12 answers. And it's complicated, you know, that Cassese was tried to be very progressive in it, saying if a crime is an international crime, then you have universal jurisdiction. And probably today, as I feel, because we have been backwards towards what was the case law of the ICY in the 90s, the end of the 90s, beginning of the 20s, probably most jurisdictions, for sure, most states would say that it's not inevitable inevitable consequence of the label of international crime. You may have international crime without universal jurisdiction. The two things are separate. Traditionally, and Grotius probably would be read in the sense, like transforming what he said, that international crime would have as a consequence universal jurisdiction. And then if you have universal jurisdiction, you have to organize it in the country. And that's the Sharon case, but not the Sharon case and all the cases, and it's up to the states naturally to regulate. As you know, most European states, the most progressive European states, finally regulated their universal jurisdiction simply because they were overwhelmed by the number of complaints and they had political problems when the US declared that NATO should leave Brussels because US agents did not grant Brussels. Spain with the Chinese. It opens so it's more comfortable to say universal jurisdiction is a different question, and you may have a convention establishing universal jurisdiction, but if you don't have this universal jurisdiction, it does not come as a consequence of the recognition of it. On the question of state exception, it's a very broad question. Maybe the question is the question of state terrorism to begin with. and next door. Not next door, but next door we have a one with that portion. There has been a tendency, if you consider also the preparatory works of the Comprehensive Convention, until it was told in 2005, there was a tendency of the state trying to introduce somewhere in the Comprehensive Convention that state terrorism will not be will not be terrorism. There would be a restriction on the cases where state would be involved. And it's probably the compromise which is now in the draft. I don't have the text under my eyes, but if I remember well, the compromise is okay because it does not forbid to include state terrorism as in the definition, different definition. It's interesting to follow in parallel because it's the same international rules, the same actors, what happened with enforced disappearances. Because with enforced disappearances, you really have the question whether you shall label a crime enforced disappearance when no state. Here, there is no question that enforced disappearance, from the core of enforced disappearances, is the state crime. It began as a state crime, but now we have the problem with all the armed groups, and naturally, simply bandits, but the armed groups, which unfortunately perform enforced disappearances without being states. And if you limit the definition of enforced disappearances to the cases where a state is involved, it gives an immunity to non-state armed groups to perform enforced disappearances without being labeled as having committed enforced disappearances, even if there are other crimes, actually, but not enforced disappearances. So it's more like the reverse question, and it's complicated. In the discussion, there was a contradiction at one point in the convention very well, because at one point it made reference to the official forces, and at one point it opened also to non-official forces. In my view, you cannot defend a position where there would be a kind of state immunity for access. Whatever the way you find, you should include the cases where the main organization, not the actor, is a state. Otherwise, the credibility is down. The way in order to introduce it is complicated. It's a question of drafting, also a question of consensus, but normally, in my view, it should be one of the imperatives of a comprehensive convention, which would have some. Naturally, now the introduction of aggression as a crime in the statute of the ICC naturally brings a new argument in favor of state crime, because aggression is by definition a state crime, even if you persecute individuals. So the limits to the discussion of state crime probably will disappear, and probably if one day we have a definition of terrorism, it will include crimes committed within the organization.
Two comments. One, your observation regarding the idea that once you harmonize terror, it harmonizes criminal law. It takes a step further the analysis of Oren Roth based on Schmidt that shows that emergency law spreads. So it's really nice to see how the inability to draw the line between terror and other aspects are simply the emergency regulation conquers everything. And regarding what Amnon said, of like wondering a bit if there's a consolidation of customary international law, or whether it stays diverse state practice. My intuition, and I'm going one step further back in history, is that it's a matter of what's the extent of the cleavage within the international community. So if you go to the 18th century, you are found in a situation in which all felonies are considered international crimes. and you therefore have universal jurisdiction. It's applied in the way of lex loci deprendi, meaning wherever the perpetrator got captured, you can prosecute him, and then begins the dispute on political. That's the beginning of the dispute on political crime, because states are saying usually we would extradite or prosecute that person, but this time the felony is politically related, and therefore we are not going to prosecute and extradite. What makes the issue even more difficult is that assassination per se, meaning to assassinate a leader of state, is considered an international crime. Originally on the basis of the idea that God puts warriors on the throne, and in the 19th century on the idea of preservation of international peace. And you have these disputes throughout the 19th century, depending on the power relationship between the monarchs and the liberal governments within Europe. And the remnants of that you find in the Convention on the International Tribunal on Terror in the 1930s are the last remnants of that dispute. So you see, actually, it's not that we are going to codification or to it simply get blurs and get clear depending on what's the extent of disagreement within the international community.
I completely agree, and I came across this project in 1998, just before the war. It's very interesting because on some aspects it's really very progressive, quote unquote. That's all. Right? On the other aspect, it's not. But when you look at it, you understand that people would consider things more simply at the time. We are complicating things. It's very interesting to do it. It should be republished because it's very interesting. And you know that along with the decision of 2011, within the STL, a new draft for Tribunal for Terrorism was planned under the auspices also of Cassese. I don't know. It has never been. I'm sorry, it's never been published. And we planned with Belligerency to have a special issue of international justice with the draft with comments. And the draft is close to the decision of the actually, but it also refers back to the project, the great time of the then we are active
Another question. I'm totally ignorant about this about international law. So there is in the debate it is when we have new counterterrorism law that is going to come into effect on the 1st of November. There is an issue of organization versus individual acts. And we have this knife wave, people go with knives, and certainly the motivation is to terrorize, the motivation is to change, political motivation, but they are not in any kind of organization. Nice. I think it's the same, and it's unclear maybe yet whether it's an organization or individual act. The question is whether this issue is a significant issue of the international law level, and whether this organizational effect, which actually from a normative perspective justifies extreme measures. When you talk about the emergency, one can say that the emergency is prompted when you have to deviate from the balance in criminal law between the suspect's rights and the interests of society. And when there is such an organization, very, very cumbersome organization, complicated, international legging and finance and all this, you have to have special measures. But when this is just a regular crime by an individual, which happens to be motivated by political motivation, okay, then it's a totally different. Whether this is an issue that is being discussed, and
just again, relates to the. I think it's part of the same idea of whether you go for the act or for the so the organization. It's just the flip side.
It's clear that perhaps we are. The national discussion is delayed. The reality because what you mentioned are events or phenomena which are fairly recent in Israel. This wave of knives attacks again on the earth, it's very recent. And for sure, the discussions, the approach in the discussions were on acts. And also it's a reaction related to the fight against emergency law in the sense that the law at the end you should come to the EU and you should come to the acts because otherwise you won't have to everything. So we have this reaction as lawyers to say keep with the acts and keep with the individuals. But probably it's a criteria of definition. I don't know of any international text, but perhaps escaped my knowledge, but international text where the criteria of belonging to an organization would be one of the distinguishing criteria. It could be an aggravating criteria too. But you could have these techniques as saying an individual who wants to spread terror with or without a political motive, but in the case of the mass attacks, I guess there is a political motive. It's not just for the fun of attacking people. So you would have the normal case where it's an act spreading terror with a political motive, and you can have an aggravating circumstance saying when it's part of an organization, then it's another level of sentencing level of punishment, etc. The difficulty naturally is to harmonize them with two levels. One of the effects, if this technique, that's by tradition, when something is only aggravating, for sure you shall interpret it restrictively. Which means when you're not sure that it's part of an organization, you would not apply the aggravating circumstance. And that's also a limitation. Whereas if it's in the definition, it's probably looser. But probably it's one of the points which we have in the discussion. Right. And it would be more simple for the question about state. The discussion about state are always high stakes. But here the Syria case is not the only one that it's tragedy, it's a price change of the paradigms. Really the approach to state terrorism is Syria, in my view, Syria. Even if it's by far not the first state for involved cases. But in this case it's spectacular. Frankly, you cannot defend the idea of assassination. Before the people of assassination before a vote, whereas the non-state groups like that's
Yeah, but this is very, very sensitive because you can extend the argument to any non-democratic regime, okay, that is terrorizing its, even if it doesn't deploy it.
Yeah, but still, yeah, completely. But we are now in front because that will probably, I hope, but I guess there will be something like a special group in Syria. There are so many move in this direction everywhere, and in this court, naturally there's a issue that and there will be a step, final step in the direction of terrorism. Because you can see it as terrorism the same way as the terrorism attacks perpetrated against the capital oil.
If you take the example of the SDR and the inability to prosecute half of the perpetrators, still you have the same problem with Syria. Could have.
You could, but my guess is that it would be the two things. Because history, and it was a genocide. It was.
The concern is always the use of the bellum aspect, because you run very quickly from terrorism to aspect of use of bellum. And when you do it with the state, that's the excuse of the Americans to dismiss the Taliban as not being the government of Afghanistan. So the risk of tagging a state as the perpetrator of of terror is then the other aspect of it.
Sure, but then again, the Syria case is a bad case or a good case. Because in this case, the use of the aspect actually is completely second.
Yeah, but we always need to remember the Afghanistan
Yeah,
case
sure, sure.
and the implication there.
But the Syrian case is not the other encounters.
Yeah,
of-
sure.
Right. Gas and,
Yeah, sure, no, sure.
I don't want to dominate, anybody has questions. So I ask another question. You said with regard to Rafik Khadiri, the court actually said this is in our jurisdiction because it has international ramifications. When does assassination of a leader does it have international ramifications? Why the Rabin assassination was not discussed as an international crime? Or
No, you're completely right. This case, yeah, it's also the. I will speak for the people who drafted the statute and then the decision, because the decision simply confirmed the statute. The situation of judges who have a statute, and I experienced it, the presiding judge of trial chamber, where the lawyers come, counsels come and say, declare that you are incompetent, and our answer in the cafeteria, not in the decision, was to say that if we are incompetent, we cannot say we are incompetent. Something. That's the problem. And if you say it's not international, then as an international tribunal, we declare it's not international. So they didn't have any choice but saying that it's international. You're right. But I'm not disturbed by an extensive interpretation of the notion of international respect, which comes with the decision probably wrapping today. If the Security Council would have to decide on the wrapping, they would say it's international. The crime of international terror is not an international crime of terror, whereas the perpetrator was Israeli citizen. The victim was only one person. The one of the reasons why naturally the only national aspect that it worked, that it's only by coincidence that in Beirut on 14th of February 2005 there were only Lebanese on the shores, because otherwise there would have been Saudis or a lot of Saudis in Beirut and international, because some of the victims would be international. So that simply doesn't work. And the argument that it had an effect on peace and security in the region worked. As a judge, I would not be uncomfortable by saying they were right. I'm saying it's international.
yeah, but any assassination of an important person has an important effect on peace and
I'm not disturbed, but personally, I'm not disturbed if the other, if you are strict with the other, as a lawyer, as a son. Under an international law, we want to discuss that, to expand too much the notion of international terrorism. That has an impact on international law, but on criminal law, I'm not disturbed if the other constitutive elements are well designed.
To give how much to give an historical context to that argument almost split international law in the early 19th century, because after the Napoleonic War, the kings of Europe are afraid of a secret cabinet sitting in Paris and managing all the revolutions in Europe. This is a transnational imagined enemy that they are really afraid of. They don't know it's an imagined one. And because of that transnational enemy, they declare that rebellion is still an international crime that gives them a right for military intervention. And later they declare that they are not going to recognize any state that its government got formed as a result of a rebellion. In response, the Americans published the Monroe Doctrine, but it's in its original meaning, and what it begins with, while the European statement says this is international law, the Monroe Declaration says it is their system and they need to keep it away from the Western Hemisphere, from the Americas. Sorry. So this almost split international law in half. Exactly that argument about whether an assassination, rebellion, whether something that is internal has international implication, and their argument was exactly that. Any rebellion disturbs the global peace, and therefore we are allowed to intervene because we created this European concept of leaders that's trying to manage the peace of the world.
This is now the Turkish argument for the Americans who got the expedition of Roth.
Good on that.
Okay. Thank you, Robert.
Thank you for your question.
And it's very good time for lunch.
Okay.
Okay.